Oops. No, that's not right. No, that's not right. Sorry, guys. 1 second. 1 second. There we go. Okay, that's better. Okay, so hi, and welcome to a new Roman law class. As you can see, things are very tentative at the moment. Very new technology, and everything is a bit haywire. So, sorry for starting late. Let's get right to it. Just so you know, there is a chat function that I will be watching. This stream is on YouTube because I'm only getting the technology I used with the previous stream, only getting the new version of that in next week. So for now, we're using YouTube. There is a chat function, so I'll be monitoring the chat right throughout the class. If you've got any questions, feel free to ask them there. And if you wouldn't mind, just, say hi. Let me just know if anyone's watching. So I know I've got on my screen, I know there are like 7 people watching at the moment. So that's nice. Oh no, wait, 16. 16 people are watching. So, just say something in the chat function and we'll hopefully just, be aware of the fact that everyone is here. So if you're having trouble finding it, let me just quickly see if I can't get an example here for you. 1 second. I'm not going to lie, this is a very interesting experience for me as well, so please don't judge me if this goes horribly wrong. Let me just see. So if you've got your YouTube open, like so, then here you'll see the chat function over there. Now, for some reason, my YouTube page is very strange and slow, but you get the idea. And I also need to apologize for the quality. At the moment, unfortunately, it is really bad because I sort of bargained on a very good internet connection, but it seems I do not have one. So we'll work with what we have. Hopefully, you'll still be able to read the slides as well. If not, please just let me know and we'll stop and figure something out. Okay, so that's enough about the preliminaries. Let's talk about actual Roman law. So today's topic is basically how rights work, and we'll be using ownership as a practical illustration. So we'll start off by talking about rights in the context of Roman law, and we'll move on towards talking about how these rights, and specifically ownership, work today. So just to remind you, we're talking about real rights. Oh, hi guys, I just saw your chats now. So just so you know, we're on a 30-second delay because again the internet connection is really bad. So if I react to your questions at inappropriate times or when it's a bit too late, please forgive me. Again, we're sorting that out and it'll go smoother in the future, I'm sure. Okay, so just so you know, this is my view of the chat at the moment. Oh, I haven't set that up properly, so it's just blank. Never mind, all of life is suffering. I'll figure something out as we go along because I don't have time to worry about the small stuff. Don't sweat the small stuff, guys. Valuable life advice. Okay, so how do rights work? And remember, we're talking about real rights and specifically ownership. So let's quickly just revise divisions in Roman law of things. That's where we started off. We talked about real as opposed to personal rights. And just to remind you, real rights in this context refers to the idea that these rights are governing the relationship between a person and a thing. Of course, the Latin for thing is res, and therefore it is a real right, if you go and translate that. Personal rights, on the other hand, govern the relationship between different people. And so the rights involved are not like the rights involved when you're working with a thing. When we're talking about personal rights, we're talking about family law, we're talking about law of contract, we're talking about law of delict, whereas real rights are primarily dealt with in the law of things. So absolute as opposed to relative rights, absolute rights, rights which apply to the entire world. Everyone is obliged to respect this relationship you have with your object or your thing, as opposed to relative rights. And relative rights, on the other hand, are rights which operate specifically with respect to another person. Only that specific person is able to violate that right, and because only that specific person is able to violate that right, only that specific person has the obligation to respect it. So a practical illustration, if I've got a nice car, anyone can damage this car, anyone can steal this car. On the other hand, if I have a contract with you, only you can breach that contract. Only you can fail to execute your obligations in terms of that contract. And so a third party is unable to violate our contractual relationship. Okay. Thirdly, we talked about res in commercio as opposed to res extra commercium. Not that important. The important thing you should remember there is objects may be within the realm of the marketplace, so we can sell it, we can buy it, we can leave it to our legates. If we were to die, we can take these objects and we can use them as our own, and they form part of our own estate, as opposed to res extra commercium, which are those objects and things which are not able to be exercised or used as your own things. They are not your property and they cannot be your property. For instance, public goods and dead bodies, things which it is not proper to own. Finally, we have the classification of things, and there we talked about a couple of those examples. Let me see if I can't quickly get to those different classifications, just to maybe illustrate this. Yeah, this is last week's slideshow. I'm just quickly skimming through it. So we talked about corporeal and incorporeal things, physical things as opposed to non-physical things, movable and immovable things. In other words, things which you can move and things which you can not move. Quite simple. So that, in a nutshell, is then what we did last week. And it's important that we talk about that now, because this week's class proceeds from the assumption that you already understand these things. But firstly, let me just quickly see if I can't get the chat here again. Guys, this is really strange. This is difficult. Okay, so before we get to the main class, I see here a question from Shannon. Is there still another assignment as shown on the test timetable? So no, what happened is the tutorial assignment you posted or you submitted, which we're marking at the moment, it's going pretty well, I think. That assignment now counts 40% of your semester mark. The previous assignment counts 40%, and the remainder of the marks are coming from the tutorial assignments you completed during the course of the semester. So that's 20%. So it's important to remember that even if you did not do as well in these assignments, because of the disturbances and everything, the university is going to be very lenient on giving you exam entrance and on determining your final mark. So I'm not exactly sure about how that works as of yet, but it does sound like you're going to have a one mark and then the best mark counts or something like that. But don't quote me on that. We'll see what we can do. For now, just do the best you can and keep on working consistently, and then you'll do well in the exam in any case. So Romy asks, will these slides be posted on ClickUp? Yes, they will. And especially considering how bad the quality is of this video, I'm really sorry about that. Also, please feel free to let me know if you experience any technical difficulties in the chat, like if the sound isn't working properly or the video just suddenly drops and dies or something like that. We're trying to do our very best to make sure everything works, but yeah, it's very new and it does not. Oh, I can just put the chat up like that. Yeah, see, so that's the chat I see. Anyway, it's all very new, and we're trying our very best to solve everything as quickly as possible. Okay, so how do rights work? And we'll be using ownership as a practical illustration, and we'll be talking specifically about real rights. So, the structure of this section of the course, we'll start off, and that's what we did last week. We started off by talking about terminology. So, what are things? And we talked about how, what a thing is. It's an object with economic value and utility. And what are rights? And we talked about the divisions we find in rights, namely real and personal. And then finally, we talked about what it means for a right to be real or personal. Now, today's class, we'll be talking about what they are, real rights now, and how they work. And ownership is an excellent illustration of this. And real rights, how they come into being, are transferred, and end will be the topic we'll be discussing in the next class. So is this part of the work in the reader? Well, partly yes. Sorry, I just saw a question. Is this part of the work in the reader? It is partly. The reader isn't very, we were always planning on giving you more information here. So the slides will be posted on ClickUp, and everything you need to know will be on the slides themselves. But I do think it would be good to give you a basic illustration of how these principles work. And of course, it's important to remember that this is also preparing you for taking Law of Things in next year or the year after next year, when you'll be discussing the South African position in a great amount of detail. So this is part of the work in the reader, but we're going to be giving you more information. Okay. So next, a closer look at real rights. When we're talking about ownership, we are of course talking about real rights, but it's important to remember that owning something isn't the only relationship you can have with that object, right? I mean, if I were to use an object in terms of another right, I still have a relationship with that object. Now, it's important to remember that if I am hiring, for instance, or borrowing the object, I do not acquire real rights. I only acquire personal rights, namely personal rights against the owner. On the other hand, when I get something like a servitude, I am exercising a real right, the same kind of right as ownership is. If I'm taking an object in pawn, for instance, if I own a pawn shop, P-A-W-N, please, not P-O-R-N, there's some confusion about that sometimes. If I own a pawn shop, then I am acquiring real rights as opposed to mere personal rights. But how that works we'll be discussing in a bit. So, ownership is the most complete real right. It allows you to do anything you'd like to do with that object, more or less. However, there are other lesser rights which are also real rights. And real rights may therefore be categorized in terms of two main sections. Ownership, on the one hand, okay, so that's the most important one, that's the strongest one, ownership. And on the other hand, we've got limited real rights. Limited because they are not quite as strong as ownership is. So if we were to represent this schematically, that's more or less how it would look. Real rights, ownership, and limited real rights. Okay, so that should make sense, hopefully. If it doesn't, feel free to drop me a comment in the chat, and then we'll try and see what we can do. Okay, so let's start off by discussing the first one of these, ownership. Ownership in Latin is known as dominion, mastery, if you want to translate it very literally. And Roman law recognized that ownership was the strongest right over a thing. It's really, really strong. Like real rights in general are very strong. If I had a personal right and you had a real right, and we were to go to court, the real right would win, generally speaking. On the other hand, if we both had real rights, it would be less clear-cut. So real rights are generally very strong. Ownership, on the other hand, is the strongest one of these rights. It entails anything you could possibly want to do with anything. So say, for instance, we could basically divide it into three categories. First of all, we've got the jus utendi, the right to use, the jus abutendi, the right to abandon, and the jus fruendi, the right to fruits. And we'll go through each of these in a bit more detail now. So the right to use, utendi. So you can find this word, this Latin word, also is hiding in something like the word utensil. In English, utensil is something you use. So you've got the right to use the thing as your property, because it is. So let's take a practical example. If I've got a car, the jus utendi implies that I have the right to drive the car. I have the right to photograph the car. I have the right to... What can you do with a car? I've got the right to go to the drive-in in the car. Whatever you'd like to do with the car, you can do it. The jus abutendi, and I just translated this as the right to abandon, because you can see the words are etymologically related. Abutendi and abandon. So abandon is derived from the verb that makes up abutendi's primary forms. And we also find this verb has also been domesticated in English in a word like abort. So this is the right to abandon a thing, but it goes, you know, it's a bigger right than just being able to abandon an object. It also entails that you've got the right to destroy the object, you've got the right to sell the object. So you can just leave it there, you can sell it, or you could destroy it. So if I've got an apple, I've got these three options. I can either eat the apple, utendi, destroy the apple by like crushing it underfoot or something because I want to make a statement, that would be jus abutendi. I could sell the apple, also jus abutendi. Or alternatively, I could just leave the apple on the ground and walk away, the jus abutendi. Make sense? Now, the last of these is a bit more complicated. The jus fruendi is the right to the fruits that the object produces. So, an object, generally speaking, does not produce literal fruits. So, for instance, a fruit tree would produce apples, right? Well, if it was an apple tree. I mean, I'm not going to stereotype fruit trees and say they all just produce apples. That would be unfair. But say, for instance, we had a tree which produces fruit. That is very clear. What are the fruits? The literal fruits. If we've got a cow, what does a cow produce? Milk. Okay, that's a fruit. That's a fruit, and now in quotation marks. The Romans called it a fruit. And tiny cows. A cow produces tiny cows. If you do, if you go through all the motions or whatever. So what happens in this case? We can say that you've got the right to use the apple, if it's a tree. You've got the right to take the cow, the tiny cow that has been produced, and make it your own property. You've got the right to use the milk then. That's all part of the jus fruendi. Now, I've used a couple of examples of things which produce clear fruits, even if milk doesn't really sound like a fruit to you. I mean, you wouldn't use it in a fruit salad unless you were a crazy person. Other objects, on the other hand, produce fruits but in different ways. So we distinguish between natural and civil fruits. Only certain objects can produce natural fruits. Cows, fruit trees, slaves. Slaves can produce other slaves. And remember, slaves were considered property. So if a slave produces another slave, the youngest slave or the baby slave is considered a fruit in Roman law, which is problematic. I would not use that in a fruit salad also, for instance. Civil fruits, on the other hand, are those things we call fruits, but which are fruits in very abstract terms, such as, for instance, the money you get from letting something out. So from leasing something, if I were to lease an apartment, okay, if I were to hire out my apartment, this apartment, the money I get in for hiring out the apartment would count as a civil fruit. So potentially any object, if you could lease it, could potentially be the source of civil fruits, right? Which should make sense. If it doesn't, again, you know where to find me, namely right in front of you. Hi. So, for example, let's take an example. The owner of a house can use it, he can rent it out, and he can receive rent money for it. He can desert the house or destroy it. All of those things he is able to do. No one can say anything. Okay? That's his full right to do. Next. It's important to remember that ownership is a right. But a right is only useful if you can actually enforce that right, if you can actually use it. And so, in Roman law, every action, every right has certain actions which serve to protect it. And you had to have an action to enforce any right. If you had no action, you had no reason to go to court. And so because ownership is a real right, it gets a real action, an actio in rem, which is the Latin. We're using quite a lot of Latin today. I'm excited. So you're using a real action because it's a real right which you're protecting. Make sense? Now remember that this actio in rem does not mean that any action is an actio in rem, because we do know there are certain personal rights, which we'll be discussing hopefully in next week. And these personal rights are protected in terms of personal actions. And so this action would entitle the owner to claim back his property from anyone who is in possession thereof. And this is a good illustration of how studying law is a lot like, going to Hogwarts. Because what happens is you're confronted by some or other problem. And then when you're confronted with this problem, the only possible course of action is to shout something in Latin. And then after you shouted something in Latin, the problem has disappeared. So you would go to court, you would say, Raven Decatio, and then the court would be like, yeah, just give him his things back. Make sense? I feel like I'm asking that a lot, so, don't judge me. Next, limited real rights. So we've discussed ownership. Ownership entails the right to use, the right to abandon, and the right to get the fruits of an object. Now, of course, not all relationship between legal subjects and things are based on ownership. So you've got personal rights like leasing and hiring, or borrowing, personal rights, which are very weak, and we'll be discussing those in law of contract. But you've also got these strong real rights. You've also got them in other capacities. So say, for instance, here I give you two examples. No, wait, I didn't. Oh, that's the next slide. Okay, never mind. So basically, you need to remember that some person other than the owner has these rights. So there is an owner, but another person is exercising owner-like rights. So it's almost like he's the owner in certain respects in terms of that object. These are real rights of a generally permanent character, absolute in nature, and powerful in law. So not letting and hiring, for instance. So some examples: security, such as pawn, servitudes, and so forth. Now, I think I do give a bit more detail on that. Okay, let's maybe quickly talk about security. So what does security mean in the context of law? Security is something that we as lawyers use to make sure that our clients get their money back. So if someone were to borrow money from you and you were unsure whether or not they would be able to repay it, the natural thing to do would be to take an object that belongs to them, one or other item that is theirs, to keep it and to say, well, if you don't pay me, I'm keeping this and I'm selling it so that I can get my money back. And that's where the idea of a pawn shop. Don't be dirty. P-A-W-N. That's where that comes from, the idea of a pawn shop. You also sometimes sell certain things in pawn shops, but that's like your soul, so don't do that. P-A-W-N, pawn shop. And in this pawn shop, you go, you say, well, I'd like 500 Rand, please. Here's a watch. It's very valuable. If I don't pay you back, you can sell it and recover your money in that way. Make sense? So that's security. You can also find other examples of security. For instance, if you've got a loan from the bank, they might often, take your house. Well, not take your house, but you'll offer your house as security. And then if you don't pay, they foreclose on the house and they sell it and they get their money back. And if anything is left over, you get the rest. Okay, but we'll be talking about that in a bit more detail, hopefully later. Servitudes, on the other hand, are rights or rights that you have in terms of specific things, especially immovable property. So you could get a right of way. So let's take a practical example. I'll draw something because I can. So let's say, for instance, I have this stand here. So this is my property. I will draw a smiley face because I'm quite happy with it. Okay, this is a very tiny screen, so that sort of turned into something else. In any case, so this is my property. Say, for instance, I have no access to any roads because here's another stand, here's another stand, here's another stand, here's another stand, and here's the road. If I have no access to the road, I can get something that we call a right of way, which is a servitude, in other words, a real right, which allows the owner of this stand to get the opportunity to use another person's land to get to his own land. Make sense? So I live here. I can't get to the road because my house just doesn't have access to the road. So I can get a servitude to get to the road in this way. So that's a servitude. That's an example, and we're talking about that in more detail as well. And there are, of course, many other examples which we'll not be bothering with because there's no need for it at the moment. Okay, so limited real rights. Let's talk about limited real rights. An owner would have the right to use, abandon, or take the fruits of a thing. A limited real right is called limited because it does not have the capacity to do all of the above. Okay, so let me just quickly, sorry, 1 second, guys. Just quickly figuring out what's going on here. Okay, sorry, so we're back. So a right is limited because it does not entail all of the above. A servitude for a right of way, that bracket has not been closed, sorry. A servitude for a right of way is limited because it allows only use. you can only use that specific piece of earth in one specific way. Namely, you can use it to cross over to your own property. Make sense? So it's very limited. But it's still a real right, and so it's still very powerful in law, but it's very limited in the extent to which you can use it. So it does not permit you to abandon the thing. You can't sell that piece of land because it's not yours. You're just using it. And you can also take the fruits of the thing. Hi. Excuse me, van de klas. So, professor kan inkomen. Excuse. Okay. So limited real rights. Let's talk about some examples here. Pawning, for instance, is a good example of a limited real right as well. So it allows you to sell the object under certain specific circumstances, but the person who keeps the object is not allowed to use it and is not allowed to take the fruits of this object. So that's another illustration of how rights may be limited, real rights may be limited. So that's in contrast to ownership, which entails all of these abilities. Okay, so now let's quickly talk about possession, which is something different entirely from actual ownership. So now, of course, as you know, we just discussed real rights. It's important to remember that possession is not a right in the strict sense. What possession refers to is a purely factual set of circumstances, namely that a person has physical control over an object. So it's a physical, factual position where a person has physical control over an object, but is not necessarily the owner, is not necessarily hiring it, is not necessarily in possession of any real rights with relation to that object. So, good examples here on the slide. We get someone hiring a car. If you hire a car and you're using it, you are in possession of that car. If a thief has stolen your watch, he is in possession of the watch. If you happen to pick up a chest full of ancient Roman gold coins by the side of a road, which is unlikely, but is not impossible, then that would also be something that you are in possession of. Now, in modern South African law, okay, let's maybe start with the Roman law position. So we need to ask ourselves, what is our relationship to these objects? So if you cannot assert any rights in terms of that object, you're just left with the fact that there's a factual state of control and you're in possession of that thing. We need to consider whether or not it would be advantageous for law to actually protect this possession, to protect someone being in possession of an object. So there are several reasons to believe that we should. So even the Romans, who esteemed real rights very highly, believed that possessions or possessors should be protected. For instance, if you did not follow due legal process, possessors were protected even against the owner. So what would be a practical example here? Say, for instance, you happen to get to a position where you have no... okay, 1 second, guys. Let me just quickly... Okay, hi guys, so we're back. Hi, okay, sorry about that. So, should we protect or should we protect the possession of the possessor? And, so practical example. If, for instance, you were to go on a holiday, you were to come back and to find someone driving your car around, would you be able and allowed to just take the car back? So you just punch someone until they give your car back. No, that would not be permissible, and so possession is protected in that instance. Even though this person is a thief, we are saying, well, you need to follow due legal process to get your object back, your thing back. Otherwise, we're going to just return the thing to the person who was in possession thereof. And so we need to talk about how this is actually present in law. How does law actually go about protecting possessors? And so you should have heard about the concept of an interdict at this stage in your career as a law student. So the interdict is an action which developed originally to protect in these sort of circumstances. It's an interim measure. It's easy to prove, and it's often interdicts are in the news in modern South African law because they're very useful in very crucial sort of situations. We've got, for instance, the public protector who is going to be in court with an interdict on the 2nd of November with regards to the releasing of that report. So you might have read about that. Okay, but we're not going into a lot of detail here. So the next section of the lecture is ownership as opposed to possession in contemporary law. And so we're using Port Elizabeth Municipality versus various occupiers as a case study. The legal position. So we need to talk about the legal position in two respects. We need to talk about pre-constitutional law and post-constitutional law. So we're starting off by talking about the common law, which is present in both, legal orders, of course. We've got the Prevention of Illegal Squatting Act, which was present in pre-constitutional law. We've got the Prevention of Illegal Eviction from an Unlawful Occupation of Land Act, 1998, which, is the post-constitutional position, though, of course, it only entered into operation 2 years after the Constitution was actually drafted. And then we get the Constitution itself, of course. Just so you know, these two acts are often abbreviated. The Prevention of Illegal Squatting Act was known as PISA, and the Prevention of Illegal Evictions from an Unlawful Occupation of Land Act is still to this day known as the PI Act, which is interesting because if you think about it, when the moon hits your eye like a big piece of pie, that's amore. So, yeah, excuse me. In any case, so let's talk about the actual case itself. Port Elizabeth Municipality versus various occupiers. So the applicant was Port Elizabeth Municipality, and the respondents were just known as the various occupiers, because you can't obviously cite all of them independently. They were approximately 68 people, 23 children, who occupied 29 shacks which they had erected on privately owned land within the municipality. So a petition was signed by 1,600 people in the neighborhood, including the owners of the property, calling for removal of these occupiers. The municipality sought an eviction order against the occupier. So this is all in paragraph 1 of the case, which is posted on ClickUp. So at that time, the proceedings were instituted. The occupiers had, on their version, been living from periods ranging from 2 to 8 years on the property. Most had come there after being evicted from other land. So they'd already been evicted, and then they just moved to this piece of land. So the sites they occupied were undeveloped land, known in an area known as Lorraine, which is interesting, within the jurisdiction of the municipality. The property was zoned for residential purposes, and the dwellings were erected without the consent of the municipality. So, on those facts, it's very clear the occupation was unlawful, no doubt about that. So the municipality submitted that it was aware of its obligation to provide housing and had for that reason embarked on a comprehensive housing development program. So it did try and solve this problem as quickly as possible. So it did build other accommodation for people in general, but then this of course opened the way for the municipality to argue that if alternative land was made available to these occupiers, they would be jumping the queue. So by occupying private land and when asked to vacate it, demanding that they be provided with alternative accommodation, by doing this, they would be disrupting the housing program and forcing the municipality to grant them preferential treatment. So the municipality's argument is there's only so much land, only so much resources available, and you can't really expect to receive preferential treatment because you broke the law. So this all went to the Constitutional Court and started its judgment by referring to how the matter would have been handled in the pre-democratic era. So the Constitutional Court specifically, of course, referred to PISA. In terms of this act, so the only question would have been whether or not the occupation of the land was unlawful. So once it was determined that the occupiers had no permission to be on the land, they not only faced summary eviction, they were also liable for criminal prosecution. So you can see how this could link up to the Roman law idea about ownership and property. Remember, the concept of ownership is not something that is, necessarily the case. You get many societies, many legal systems which do not consider ownership in quite the same ways as we do. So in South African law at least. So what that means for our purposes is we need to see how this act could be related back to the Roman law position. And so did this act replace the Roman law? That's an important question. We need to think about how acts interact with the Roman law. The Roman law is the basis of South African law, and acts may adapt or change this position. But where the act does not apply, the Roman law is again in operation. So this act only applied specifically to illegal squatting. So it protected ownership in a very limited sense. But it's also important to remember that many times acts depend on Roman law concepts, such as ownership, for instance, and everything that goes with it, in order to determine what exactly the act's operation will be. So, thus, even if they had been born on the land and spent their whole lives there, persons from whom permission to remain on the land had been withdrawn by the new owners were treated as criminals and subjected to summary eviction. So that's the idea. In terms of this old act, if you had permission and had been withdrawn, you had to leave. PISA was an integral part of a cluster of statutes that forced black people to live in racially designated locations. So we already discussed this earlier in the course. So for instance, we've got this the Native Urban Areas Consolidation Act, 2545, which was premised on the notion of Africans living in rural reserves and coming to towns only as migrant workers on a temporary sojourn. So the idea was your primary residence was in a reservation or was in one of the reserves, and then you only came in to work on a temporary basis, and then you would return eventually. So through a combination of spatial apartheid, permit systems, and the creation of criminal offences, this act strictly controlled the limited rights that Africans had to reside in rural areas. And so people living outside of what were defined as native locations were regarded as squatters and, under PISA, were expelled from the land in which they lived. So these acts, you should see how they interacted with one another. Next slide. So let's link this back to Roman Dutch law. The owner was entitled to possession unless the occupier could raise and prove a valid defense, usually based on agreement with the owner. So we talked about that in the previous class. It is within the capacity of the owner to limit his or her own real rights. In Roman law, you can limit your own rights by agreement. So, for instance, if I'm leasing your property, you undertook not to use your rights or your real right is not. You undertook not to exercise that real right in respect of that property, and so because of my personal right, I have the right to remain there. So, of course, the squatters in this case had no such agreement, and accordingly, in terms of PISA, they would have been expelled. So you can see here on the slide, this principle had disastrous results for non-owners under apartheid land law. The strong position of ownership and the weak position of black non-ownership rights of occupation made it easier for the architects of apartheid to effect the evictions and removals required to establish the separation of land holdings along race lines. And this is a quote from the article in your reader, if I'm not mistaken. Therefore, although Roman law and Roman Dutch law of ownership are presented as neutral and impartial, so in that sense, it did enforce inequality and racism in South African property law because it protected the established norms of land ownership. Because it's not like the Constitution, which has a transformative agenda, a transformative mandate. The Roman law sought primarily to maintain the equilibrium, to maintain ownership. If you were the owner, you would remain the owner, barring other circumstances. Okay. So let's talk about property rights in the light of the Supreme Constitution. In assessing the plight of the occupiers, the Constitutional Court analyzed the constitutional provisions that protect property rights. Section 25(1) states, no one may be deprived of property except in terms of law of general application, and no law may permit an arbitrary deprivation of property. So that's Section 25 of the Constitution coming right in and saying that yes, property and the concept of property and of ownership still exists in South African law, and importantly, it is protected and entrenched in the Constitution. You may only be deprived of this property in terms of law of general application, and no law may permit an arbitrary deprivation of property. Of course, Section 25 doesn't stop there. Section 25, 4 to 9 are aimed at redressing the grossly unequal distribution of land in South Africa. So that's an important point to remember. is that although the Constitution does assert, in principle, yes, property does exist, and it is protected and entrenched in the Constitution, it may still be limited. This right may still be limited, and the property may be redressed, or redress in terms of actual material property may take place in terms of sections 4 to 9, and we'll be going through those in a bit. So the Constitutional Court in this case held that the purpose of Section 25 was to be seen as both of these. So we're protecting existing private property rights as well as serving the public interest, mainly, of course, in the sphere of land reform. Okay, so Section 26 of the Constitution. Wait, hold on. No, sorry. This is a typo. This should be... sorry, this is 26. Sorry, yeah, I just sort of assumed. 26.1, everyone has the right to have access to adequate housing. Okay, so that's parallel right. And then, of course, Section 26.2, the state must take reasonable legislative and other measures within its available resources to achieve a progressive realization of this right. Thirdly, no one may be evicted from their home or have their home demolished without an order of court made after considering all of the relevant circumstances, and no legislation may permit arbitrary evictions. So you can see how both of these sections play into the present case. So let's talk about the relationship between these sections. On the one hand, we've got the rights of a dispossessed people will not be immediately fulfilled. Section 26 has been interpreted to mean a process of progressive realization. So if you've heard about the Grootboom case, in this case, the court determined that progressive realization is the way in which Section 26 is exercised. The court or the state does not have the resources to provide housing for everyone immediately, and accordingly the state's responsibility is to progressively realize it. So the Constitution is strongly supportive of orderly land reform, we can say. So it's saying, well, we should not just take property arbitrarily, we should not take property immediately, we should take property in a sense, we should move towards giving everyone what they need, but to do so in a way that is progressively realized, at least. It does not sanction the arbitrary seizure of land, we discussed this. And the state, the rights involved in Section 26.3 are defensive rather than affirmative. Okay, so let's talk about 26.3 again. No one may be evicted from their home. So 26.3's function in this case would be to protect these squatters, would be to say, no, you're not allowed to just break down these these squatter camps, because people are living there, that is their homes, and Section 26.3 does protect that. Okay, so ownership in terms of the Constitution. Okay, so we discussed this as well. I think we can skip this slide. Again, I think we did that in quite a amount of detail. Yes, the right of ownership as opposed to the right not to be arbitrarily evicted. Because in this case, this is where the court found the locus of the dispute between these two rights. So the Constitution imposes new obligations on the court concerning rights related to property not previously recognized by the common law. So the rights of possession, use, and occupation are protected in terms of the common law, but they are weighed against a new and very equally relevant right, namely the right not to be arbitrarily deprived of a home. The expectations that ordinarily go with ownership could clash head-on with the genuine despair of people in need, or dire need of accommodation. So Roman law, just as it is, would basically come around and say, no, you are the owner, your rights are more or less absolute, you can do whatever you like, and if someone is on your property, well, they may not be there, they should move and they should leave. The judicial function in these circumstances is not to establish a hierarchical arrangement between the different interests involved. Okay, so let's talk about this paragraph here. I'm going to start off by reading it and then I'm going to be explaining it. So, we already said the judicial function in these circumstances is not to establish a hierarchical arrangement between the different interests involved, privileging in an abstract and mechanical way the right of ownership over the right not to be dispossessed of a home, or vice versa. So that first sentence says, the court's function is not to say, this is the right that wins, this is the right that wins. Okay? It's not an either or. Rather, it is to balance out and reconcile the opposed claims in as just a manner as possible, taking account of all the interests involved and the specific factors relevant in each particular case. So the court is not supposed to say, no, the right to ownership is always stronger than the right to housing, or alternatively, the right to housing is always stronger than the right to ownership. The court's function is to say, well, in this specific instance, this is how it weighed. This is how we weighed it up. Make sense? And to give guidelines for how these decisions should maybe be taken in the future. But not to say, always, 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 this is now the rule, ownership is stronger than accommodation and vice versa. Make sense? Okay, so the PI Act. Let's talk about that act. Very important act, and very important act in the context of this lecture. Did it replace the common law? To a large extent, yes. To the extent that the PISA Act did not already replace the common law, it did. But it's still based on the common law. It still makes use of common law concepts such as ownership and everything that entails. So the common law is still really important. You can't afford not to know it, even if it is only with respect to land. So the Prevention of Illegal Evictions from and Unlawful Occupation of Land Act was adopted with the objective to give effect to Section 26(3). In terms of PI, the municipality had to fulfill two requirements in order to apply for an eviction order. Namely, firstly, that the occupation is unlawful and the structures are either unauthorized or unhealthy or unsafe. So let's think about this. Would PI be applicable in this case? It looks like it. But it's important to remember that in terms of Section 6, if these requirements are met, the court then has a discretion to grant an eviction order if it is just and equitable to do so. So it's not mechanical. It's not like the court must necessarily do so. The court has a discretion to do so. So in making its decision, the court must take account of all relevant circumstances, including the manner in which occupation was evicted, its duration, and the availability of suitably alternative accommodation or land. Okay. Let me just quickly check. Are there any questions? Everyone's so quiet, right? Let me just quickly check my analytics. So there are quite a lot of people watching, actually. So please, let me know if you've got any questions. Because, this is very different from just giving a class normally. So I'm just going to drone on if I have nothing to respond to. I like seeing your faces, guys, but if I cannot, I'll just have to be satisfied with reading your words. Okay. Circumstances relating to occupation. So the court needs to consider the manner in which occupation was effected, its duration, and the availability of suitable alternative accommodation or land. That's what we need to consider. Circumstances relating to the occupation. Different considerations could arise depending on whether or not the land occupied is publicly or privately owned. So in terms of public land, the state, it generally has an obligation to meet these needs in any case. So it still has to fulfill 26. It has to fulfill 26 in any case. But in the case of privately owned land, a private owner has no real obligation to fulfill these rights. That's a bit strange to say, right? So private land may be derelict, which means that the owner is having little practical interest in its utilization, and public land might be set aside for important public purposes, including, of course, the provision of housing. And this is something we see very often, is where land is set aside for housing to be constructed on, and then people unlawfully occupy this land. And because they unlawfully occupy this land, it cannot be used to actually provide proper and adequate housing. So it's problematic. Do you get rid of these people and build new houses? Do you build new houses for these people so you've occupied this land, and so we're building a house for you where your shack stood and giving you alternative accommodation. Meanwhile, it's a headache, guys, to think about the financial implications, and it's very difficult for the state to actually provide housing in those circumstances. But of course, people need somewhere to live. People need somewhere to sleep. So there's no real easy answers. Okay, so the motivation for settling on land could be of importance. So we need to think about, why are people settling on this land? So if it was an emergency situation or people were desperate, then we'd have to consider whether or not that might not weigh in their favor. Furthermore, persons occupying land with at least a plausible belief that their permission to be there could be looked at with far greater sympathy than those who deliberately invade land with a view to disrupting the organized housing program and placing themselves at the front of the queue. That's important. We did get this situation a while back where someone claimed to have sold land to people. So it was a former employee of the municipality in Johannesburg, I remember. I think, if I'm correct. And this former employee convinced squatters that he was selling them land. So they would pay like 500 Rand for a couple of square meters, and he would just pocket the money, and they didn't become the owners. So they believed they were the owners. They believed that they had the right to be on that land, but they didn't. And what this is saying is that, well, if you're in that sort of situation, we can be a bit more sympathetic because you did not operate male fide. That's an important Roman law term, and I think I can just quickly introduce here. Male. Male, M-A-L-E, fide. Male fide, as opposed to the opposite, which is bona fide. And male fide means you operated outside the norms of what is proper. Your intentions were dishonorable. Bona fide means your intentions were good. Make sense? Okay, next. The period the unlawful occupier and his or her family have been on the land. That's the next thing we need to consider. So there's no set formula. It's something that's purely in the court's discretion. It's just about fairness. If you've been there a long while, if you've been there for a long amount of time, well, then it isn't really fair for you to be moved aside just, on a short, just so quickly. So the idea is we're saying, if you've been there for a long time, you've got a greater interest in the land. You've got a greater chance of being allowed to stay. Okay, and then finally, the availability of suitable alternative accommodation or land. So section 6.3, the court needs to consider whether or not suitable alternative land is available. So there's no unqualified constitutional duty on local authorities to provide alternative accommodation before eviction can take place. So you don't have to, if you're a municipality, you don't have to give alternative accommodation necessarily, but the court should be reluctant to give an order for eviction if suitable alternative arrangements have not been made, which is just fair. Okay, considering all the relevant circumstances, so what do we see? It seems that the court, in terms of the PI Act, as opposed to the PISA Act, which was very mechanical, in terms of the PI Act, the court has a wide range of discretion. The court could do more or less anything that it believes necessary to ensure and effect a fair outcome. Just and equitable, key words. So when applying PI, it is the duty of the court to aim to balance competing interests. So there's a real right inherent in ownership, which deserves protection. It's reserving exclusive use and protection of property by a landowner. So that's in terms of Roman law and Roman Dutch law, and in terms of Section 25 of the Constitution, 25.1 specifically. And then, on the other hand, there is this actual need for housing for people who need somewhere to stay. So the use of this term relates to both interests. It is not only equitable to those people who are the owners of the land, but it's also equitable to those people who need to live there, even if they do live there illegally. And then finally, when deciding on a matter of this nature, courts would be obliged to break away from purely legalistic approaches. So we need to have regard to extraneous factors. We need to think about the underlying circumstances. Okay, so just so you know, we're nearly at the end. So if you've got a question, now would be a great time to start typing it. Constitutional approach to ownership and eviction. So the new approach to land ownership in particular, which is very different from the Roman law approach, is that in addition to considering the lawfulness of the occupation, so in terms of not only considering the legal issues, we need to look at the interest and the circumstances around the people and their circumstances. So why are they there? Why do they not have other accommodation? And will they be okay if we suddenly just turn them out on the street? On the other hand, under the common law, unlawfulness of occupation was enough to secure an eviction. This approach benefited the owner and severely disregarded the rights of particularly black people, because particularly black people were those who did not own the land. And the approach in terms of the Constitution seeks to achieve a more just result. But do remember that eviction, in terms of Roman law, would also have to occur through a court process. So we did say that possession was protected by an interdict. So if you just removed someone suddenly, that would not be permissible. You had to follow the court procedure. But of course, court procedure was far less forgiving towards unlawful occupiers than the modern PI Act is. So that is basically it, guys. I don't know what to tell you more than that. If you've got any questions, I'm going to stick around for a second or two to see what I can find. But yeah, so I'm thinking of scheduling another class on say Thursday. I'll let you know as soon as I can. It's a bit tricky because I had to set up a couple of things and it's hard to know when the internet's going to be working properly. But hopefully by Thursday we'll have a second class, and then in next week you might be coming into campus. Sounds like. We don't know yet. But in any case, we'll let you know as soon as we have the information. Anyway, guys, so you're coming into campus, not like as the university as a whole, but there was talk of maybe scheduling lectures specifically for first years law students in next week. But again, we'll let you know as soon as we have more detail. Anyway, have a great day, guys. And if you've got any questions, you know where to find me. You can contact me by calling me 8 to 11 every day except Fridays. But, call in any case. We'll see what we can do. Or by emailing me. And my email address is on ClickUp as well. So please let me know. And good luck. Have a great day.